Hello, my name is Belinda Kreider, and my topic for my proposal is assisted dying. Um, and I decided to argue for it because I thought it would be very challenging, which it is. Um, I've done very much research, and I personally don't support it. However, I'm going to try to make my argument for it. Now, I think that assisted living should be established as a federal law to include strict details on assisted death process and procedures, to make assisted death definition and process as clear as possible in all states, to make guidelines for requirements, stipulations that must be followed in all cases, to make guidelines for requirements will take probably years and years to do, and it should stipulate just how and who can be involved, such as family members, healthcare providers, what their exact roles are. I'm asking for a federal level because assisted suicide would have to have a documented paper trail of forms to be filled out by the patient from the time the patient sees their primary care physician about asking questions about assisted death. The stipulation should include that the patient is still in their right mind, not under the influence of any drugs that will inhibit their mental capacity, and should be required to re-sign at periodic time frames throughout the process to make sure that this is still what they want, and to make sure that they're not being guided by family members or medical health professionals. And assisted suicide has concerns for making sure that it is done for the right reasons. And the right reasons would include such things as medical documentation showing a history of declining health, serious issues that cannot be healed or gotten better, that it's not a medical misdiagnosis, and there should be documentation of medical opinions of two separate physicians agreeing with the diagnosis after each one conducts their own series of testing and evaluations, and share the information with the family and the patient that the patient still wants to die this way. This needs to be checked on to make sure that the patient doesn't change their mind, and the patient is mentally competent to understand that this is what they want, that this is a permanent decision because it can't be reversed once they do this. And that is why we also ask for a paper trail, documentation that the patient asked for these services, that the patient knew the results of the services, how, if the doctor is going to assist, is the doctor just going to prescribe, so that everything is followed like a living will type of thing. And I think that a living will should be brought into this assisted dying, because it should be documented and recorded in a court process that this is the part of the will, that this is what they want and not anyone else. So that should also be part of their paper trail. And then I think that the patient should continue to sign their request for assisted dying at certain intervals to make sure that the patient is still wanting that process. The patient needs to be actively involved in the process as long as they are competent to do so. And how my legislation would be consistent is that there are previous cases of people wanting help with dying. However, the courts don't see this don't see that physician-assisted suicide is a protected liberty interest under the Constitution. For example, in the case of Vaco versus Quayle in 1997, this is a landmark decision of the Supreme Court of the United States regarding the right to die. In brief, the decision established that as a matter of law, there was no constitutional guarantee of a right to die. The case of Washington versus Glucksberg, where 4 doctors, 3 terminally ill patients, and a nonprofit group brought a suit challenging the state of Washington's ban on physician-assisted suicide. They argued that the ban was unconstitutional because it violated due process. Now, these cases dealt with the constitutionality of Washington statute that made it a felony for a person to assist in the suicide of another. According to the statute, a person is guilty of promoting a suicide attempt when he knowingly causes or aids another person to attempt suicide. In Michigan, the case of People versus Kevorkian, who was a doctor, was indicted on 2 counts of murder roughly a year before the state enacted a statute prohibiting assisted suicide. The Court of Appeals reversed, and Kevorkian appealed to the state's Supreme Court. Now, the maximum punishment for conviction was 5 years imprisonment and a $10,000 fine. Another statute in Washington, the Natural Death Act, provided withholding or withdrawal of life-sustaining treatment at a patient's direction shall not, for any purpose, constitute suicide. In the case of Bush versus Chavo, Chavo lived in a vegetative state for over 10 years due to a cardiac arrest. After about 8 years, her husband, Michael Schiavo, petitioned the court to authorize the termination of life-prolonging procedures. The court granted his request, and the nutrition and hydration tube that had been prolonging Shiva's life was removed. 6 days later, the Florida legislature enacted a statute enabling the governor to issue a one-time stay to prevent the withholding of nutrition and hydration from a patient if the patient had no advance directive. The court would rule that the patient to be in a persistent vegetative state, the patient had had nutrition and hydration withheld, and a member of that patient's family has challenged the withholding of the nutrition and hydration. A number of physicians and their terminally ill patients brought suit to challenge the constitutionality of the assisted suicide law. These plaintiffs claimed the existence of a liberty interest protected by the 14th Amendment, which extends to a personal choice by mentally competent, terminally ill adult to commit physician-assisted suicide. The district court agreed with the doctors and patients. The court ruled that the law placed an undue burden of exercise of a constitutionally protected liberty interest. The state appealed the case to the Ninth Circuit Court of Appeals. A 3-judge panel reversed the district court according to that opinion. This country has never recognized a constitutional right to aid in killing. In Gonzalez versus Oregon, Oregon passed a physician-assisted suicide law in 1994. The U.S. Attorney General issued a rule stating that the law violated the Controlled Substances Act of 1970. Oregon sued in federal court, challenging the Attorney General's rule. The District Court and the Ninth Circuit Court of Appeals held for Oregon. The Supreme Court affirmed those decisions. The court found that the Attorney General's rule was invalid, so the Controlled Substances Act does not give the Attorney General power to regulate the medical profession in general. So, in these cases, even though they might have temporarily been able to do what they needed to do, however, it was always a higher court that came back and reversed the judgment of these cases. But all in all, Oregon in 1994 passed the first physician-assisted suicide law in the nation. It was called the Death with Dignity Act, and the law permitted physicians to prescribe controlled substances in lethal doses to terminally ill patients in 2001. The U.S. Attorney General John Ashcroft issued an interpretive rule stating that the assisted suicide law violated the Controlled Substance Act of 1970. So, since then, there has been I believe a total of 9 states that actually have some sort of law that supports the assisted suicide, the right to be removed off of life-expanding machines like respirators and feeding tubes if the patient is in a vegetative state. Now, there are several arguments, such as a deadly mix with our profit-driven healthcare system, that, they make money, off of all of this, just like with anything else. Assisted living puts vulnerable persons at risk of abuse or coercion. It's a dangerously broad definition of terminal illness right now, so that needs to be with this federal, it should be a standard with everyone, with all states. Pain, not the primary issue. No psychiatric evaluation or treatment is required. Threatens improvement of palliative care. Now, there is not a right to due process for dying with dignity. There are, of course, many arguments, as I have mentioned, against assisted suicide, including even medical misdiagnosis, patients not having insurance, family members concerned about their inheritance, such issues as that. There's a lot of questions to this, and I see that, unfortunately, I believe that many more states are going to support this down the road because of the healthcare cost going so high. So I thank you for your time.